Could Mary filing separate be on the chopping block for student loan borrowers out of nowhere with no warning whatsoever in direct violation of federal statute? This is very concerning, this recent development from the Acting Undersecretary of Education. And this came out of nowhere in response to a lawsuit filing that was trying to reopen the IBR plan. And it could portend even more legal battles and struggles and lawsuits in the future. And it could have major implications for millions of student loan borrowers. I hope this video is alarmist to look silly in a few weeks after I record this, but I needed to record it to show you what is at stake and what is going on behind the scenes with what I believe the Department of Education is trying to do in violation of statute. So let me explain what I mean. So this lawsuit from the American Federation of Teachers was filed versus Department of Education, specifically to reopen the IBR plan for processing because its members of the American Federation of Teachers were not able to get PSLF access because Department of Ed refused to allow people to switch plans. IBR is statutory, which means it's written into the law by Congress specifically. It's not subject to the injunctions that have been happening in the courts. So Department of Ed has not allowed people to sign up for IBR. American Federation of Teachers sued them to try to force the issue. And what happened is the Acting Undersecretary of Ed responded to this lawsuit and put a comment in this that might have been an accident, but it's quite concerning because it says, number 18, education expects by May that servicers will implement treatment of spousal information for IBR, ICR, pay, and IBR, such that married borrowers filing separate income tax returns or separated from the spouses will have spousal income counted for the purposes of calculating monthly payments under IDR plans. And they're claiming that this is a required consequence of the Eighth Circuit's opinion directing a broadened preliminary injunction. Now, if you look at mohila.studentaid.gov, there is a comment here that says that IDR processing has resumed for these who file as single or married with no income. All other IDR applications will remain on hold at this time. I wonder why, right? That kind of lines up with this pronouncement that they will no longer allow married filing separate as of May 10th, 2025. Well, what does the actual statute say? If you look at the statute for income-based repayment, you can see here in subsection D, special rule for married borrowers filing separate. In the case of a married borrower who files separate, the Secretary shall include the amount of the borrower's income-based repayment under this section solely, it says solely, on the basis of a borrower's student loan debt and adjusted gross income. So that's very specific. It very much says it in the statute. Now, these are regulations. When you see CFR, that means regulations, which is, the executive branch is essentially interpreting what Congress did. Now, in this was changed by President Biden to throw the repay and save plan in with different plans that allow you to file taxes separately. So the Acting Undersecretary of Ed perhaps is saying, well, that means that this is paused because the courts paused the whole new IDR rule. That's not the case because the statute's explicit. It allows you to do married filing separate for IBR. So why are they saying this? It makes no sense because it's in violation of what the statute says. So what we have to do if you're a borrower is pay close attention to what Department of Education is doing. We have to make sure the Department of Education acts according to the statute. If they want to change the statute, then they need to pass a law in Congress to do so. If they say that their interpretation of the statute is that married filing separate for some reason is not allowed, even though it says it very clearly is allowed, then you can expect a lot of lawsuits coming in the coming weeks that might take a while to resolve. So I hate to say expect more student loan chaos, but it certainly seems like Department of Education is unable or unwilling to do their job according to what's written into the statute. And as a result, they're potentially making the argument that married filing separate will not be allowed anymore for student loans, which would mean higher student loan payments for millions of people. Now, was this an accident? Was this an honest mistake? Or is this something that they are planning to implement? Either way, we need to raise the alarm bells to let borrowers know that something that's statutorily promised to them might be being attempted to be ripped away in violation of what's written clearly into the statute. So again, it's very clear. It's written here. It's not something that you can have the executive branch just eliminate because they feel like it. So we'll see what happens. If you have any questions, put them in the comments. If you have a representative that you want to email about this or contact about this, or senator you want to email or contact about this, let them know if this is important to you, because this would mean, in some cases, thousands of dollars per month in additional payments and a pretty large penalty for being married to someone from a perspective of much, much higher payments. So is that what Congress intends? I don't know. If it is, then they should write it into law and they should change the law. So if you have questions about this married filing separate unexpected development, put them in the comments. Thank you for following Student Loan Planner.